I'm Larry Chartrand, Academic Director of the Native Law Center at the University of Saskatchewan. Over the course of my career, I've been dedicated to developing educational initiatives, law and policy that impact Indigenous rights and access to justice. I was asked to prepare a report for the National Aboriginal Lands Manager Association, NALMA, on the subject of Quebec family law as it relates to the family homes on reserves and matrimonial interests and rights law. That is a mouthful, so I will now refer to it as the Family Homes Law or the Act. In doing so, I examined the potential conflict between federal and provincial laws regarding matrimonial property. I would like to summarize some of the conclusions that I have arrived at and observations I have made for the benefit of First Nations members who will be impacted by the legislation and for those who will be tasked with administering or implementing the laws. First off, I think it is important to clarify a point regarding the federal government's rationale for enacting the Family Homes Law. The federal government has characterized the legislation as filling a gap in the law because there were no existing mechanisms for First Nations and courts to deal with issues such as division of marital property in the event of a spousal relationship breakdown. I think it is more accurate to state that the gap was not due to the lack of matrimonial property law on reserves, but was created by the lack of recognition of First Nations authority by the historical imposition of colonial authority and by the devaluing of women's legal status. The Act does, to some extent, address past marginalization by recognizing the authority of a First Nation to enact its own laws or codes concerning matrimonial property issues. I believe that there are some important differences between the application of Quebec matrimonial law and the Family Homes Act. However, many of the differences can be justified due to the unique political, cultural, and legal regimes that exist on reserves as compared to Quebec generally. One of the differences worth noting relates to the kinds of conjugal relationships that are legally recognized. In Quebec, conjugal relationships established by marriage and civil union are legally recognized, and in these cases, the specific rules of matrimonial property law will apply. The third kind of conjugal relationship is called a de facto union. In other provinces of Canada, this kind of relationship would be called a common law marriage, and the matrimonial property laws that exist in the provinces usually apply. However, in Quebec, there is no legal significance given to such de facto relationships. The domestic partners under such a relationship are considered no different in law than roommates, regardless of how long they have lived together, and there is no assumption of mutual ownership of family property. Importantly, however, under the Family Homes Act, such de facto relationships are given legal recognition and are treated the same as common law marriages for the purposes of the Act. This means that in Quebec, those living on First Nation reserves will have the benefits of the Family Homes Act matrimonial property rights regime, regardless of whether the union is one that is the result of marriage, civil union, or is a de facto union. Under the Constitution, the Family Homes Act is a valid federal law. Should any provincial law be in conflict, the federal law and First Nations codes will most likely prevail. For instance, Quebec law says family law rules will not apply to common law relationships, whereas the Family Homes Act rules say that family law rules will apply to common law relationships. In this situation, constitutional law states the federal rules are to prevail over Quebec law. In short, there is technically some room for provincial law to continue to apply, but the Federal Homes Act is very comprehensive and it is likely to prevail over any comparable provincial law. It is my opinion that the Family Homes Act can allow for justices of the peace or provincial court judges to address such issues as emergency protection orders, but it is less clear whether Quebec courts have jurisdiction to administer the laws of a First Nations code, because it is unclear whether First Nations codes are based on self-government authority or is delegated authority under the Federal Act. In my analysis of the legislation, I have concluded that the Family Homes Act recognizes First Nation authority, which is very different from granting First Nations authority, though this is not the view of federal government lawyers and policy makers. It is interesting to note that the Family Homes Act does not include a clause that clearly states that it will not nullify Aboriginal treaty rights, though there is a preamble statement with language to that effect. Preamble statements have no legal force, but they can aid in the interpretation of existing provisions. The statement reads, quote, "Whereas this act is not intended to define the nature and scope of any right of self-government or to prejudge the outcome of any self-government negotiation," unquote. I believe that it supports my argument that the Family Homes Act recognizes, rather than grants, the authority of First Nations codes. Miigwech.